modesty. That is what the word which has been. But
Yes.
it is also of some relevance for lordships to kindly note that on the very same day, the respondent number 2 also made a complaint before the Honorable Chairman of the Karnataka Legislative Council in respect of the same incident. The Honorable Chairman of the Karnataka Legislative Council, my lords, is said to have given a ruling on that complaint after hearing me. It is thereafter, my lords, a complaint, first information is lodged before the jurisdictional police, and this section 77 and 78 is, my lords, registered. This petition, my lords, primarily is on the ground that registration of the first information report is barred under Article 194, subclause 2 of the Constitution. Therefore, if lordships, I'll just briefly take lordships to what are the lords heads on which lord this argument is built up, and then lord elaborate if possible.
Yes, sir.
Internal page 3 if lordships are given. Internal page 2. First question.
Yes.
ಈಗ ನಮ್ಮ ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್
submission.
ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ ಅಂದ್ರೆ ರಿಟರ್ನ್ ನೋಟ್ ಅಂತ ಮಾಡಿದ್ವಿ.
ಆಯ್ತು.
ಪೇಜ್ 2 ಅಲ್ಲಿ left hand side para 5 notes. These are the questions according to us would arise for lordship's kind consideration.
All right.
Number 1, whether the protection given to a member of the legislative council from any proceedings in the court of law as contained in Article 194(2) of the Constitution of India is a qualified protection. But the second question is what will be the true and scope of jurisdiction? I will not request lordships to kindly consider it later on, but kindly see third one. Whether the registration of the first information report by the jurisdictional police in respect of the words spoken by the petitioner inside the house would be barred having regard to the constitutional injunction as under Article 142 of the Constitution of India. But these will be the two broad questions, but ultimately. The reason why we have raised these questions is, at the time when the matter was presented before your lordships initially, two aspects came into force. First, number one is, whether anything said when the house is really not in session, that was how the learned SPP had argued, whether a protection can be extended under Article 194(2). Secondly, lordships did observe and some discussion took place. What happens if a derogatory word or a word which constitutes an offense under the criminal procedure, IPC is committed? Will the protection also continue to 194(2)? That's the two questions. Now, lordships may kindly see Article 194.
Yes.
Lords, 194(1) lordships may kindly permit me to read. Subject to the provisions of this Constitution and to the rules and standing orders regulating the procedure of the legislature, there shall be freedom of speech in the legislature of every state. But this is very interesting. The Honorable Supreme Court says the importance of this. There is already a freedom of speech as available under Article 19. There is restriction under Article 19(2), the reasonable restriction. What the Honorable Supreme Court interprets 194(1) to say is, this freedom of speech given under 194
has no restriction.
There cannot be having any restriction except the rules and standing orders regulating the procedure of the legislature. Therefore, they make it an in-house procedure. State executive comes out of the session of 194(1). That is the importance I wanted to place. Now, 2 is what we really rely upon. No member of the legislature of a state shall be liable to any proceedings in any court in respect of anything said or any vote given by him. We are not really concerned with that. By him in the legislature or any committee thereof. And no person shall be liable in respect of the publication by or under the authority of a house of such legislature of any report, paper, votes or proceedings. But a true and correct interpretation of Article 194(2), as I have understood, is that for anything said in the legislature, you cannot be subjected to any civil or criminal court, any court for that. It is 194(3), which relates to privileges and immunities, powers of the legislatures, which I am really not, do not think we would be advancing any argument based on 194(3). But if lordships feel it necessary, I'll read that as well. In other respects, the powers, privileges, and immunities of a house of the legislature of state and of the members and the committees of the house of such legislature shall be as such as may from time to time be defined by the legislature by law, and until so defined shall be those of the house and its members and committees immediately before the coming into force of section 26 of the constitution, so and so. The provisions of clause 1, 2, and 3 shall apply in relation to persons who by virtue of this constitution have a right to speak in and otherwise take part in the proceedings of a house of the legislature of a state or any committee thereof, as they apply in relation to the members of the legislature. The 194 is really meant for Advocate General Mullards, who can, though not being a member of the legislature, can still address the house as well. That is the extra precaution the constitution has taken insofar 194(4) is concerned. But what, which therefore we have used the word, there is a constitutional injunction not to proceed against any member of the legislature in any court of law for anything said to him. Now, these two questions, which has been raised, according to us, have been dealt by the Honorable Supreme Court. Therefore, I'll straight away take lordships to both the questions. Internal page 3. Copy. But according to us, absolute immunity granted to legislatures, irrespective of whether the house is in third page. Sorry, sir, written submission. I'm sorry. Whether that session whether session is, for instance, in this case, they say he had adjourned the house and chairman had left the chair. That is one of the arguments which has been advanced, which according to me, cannot be really gone into, but that also has been considered in Sita Soren. May I read it? Yes, lordship in order to make it easy, we have extracted the relevant portions in that written submissions itself.
All right.
So that lordships find it easy. Internal page 3, paragraph 9.
Yes, sir.
The Honorable Supreme Court, in the case of Sita Soren versus Union of India, expanded the proposition about the conscious use of the term legislature instead of the house of the legislature in the text of the provision. Distinct from the marginal note in the text of the provision, there is a conscious use of the word term legislature instead of the house of legislature at appropriate places. It is evident from the drafting of the provision that the two terms have not been used interchangeably. The first limb of Article 194(2) pertains to anything said or any vote given by him in the legislature or any committee thereof. However, in the second limb, the phrase used is in respect of the publication by or under the authority of a house, such a legislature of any report, paper, votes, or proceedings. There is a clear departure from the term legislature, which is used in the first limb, to use the term house of such a legislature in the second limb of the provision. It is clear, therefore, that the provision creates a distinction between the legislature as a whole in the first limb, that is right to vote, and the house of the same legislature in the second. Second limb is not publication made. As correctly submitted by so-and-so, senior counsel for the appellant, the terms house of legislature and legislatures have different connotations. House of legislature refers to judicial body, which is summoned by the governor pursuant to Article 174. The term legislature, on the other hand, refers to wider concept under Article 168, comprising the governor and the houses of the legislature. It functions indefinitely and continues to exist even when the governor has not summoned the house. The use of the phrase in the legislature instead of house of legislature is significant. There are several parliamentary processes which do not take place on the floor of the house, that is when it is in session, having been summoned by the governor. For instance, there are ad hoc committees, standing committees, which examine various issues, including matters of policy or government administration. Many of these committees do not deliberate on laws or bills tabled in the house or cease to function when the house is not sitting. There appears to be no reason why the deliberations that take place in such committees, anything said, would not be protected by parliamentary privilege. Then, Lords, their Lordships, Lords, deal with voting aspect, which obviously is not when the session is done. Therefore, Lords, the conclusion in Sita Soren is that the word legislature has been consciously used.
Yes. Yes, sir.
Please. ಇದು ಯಾಕೆ ಒರಿಜಿನಲ್ ಜಜ್ಮೆಂಟ್ ಯಾಕೆ ಅಂತೀರಿ? No, anything said straight away. We'll go to anything.
So these are the paragraphs in.
Yes, these are the paragraphs only for this first proposition. One minute, just don't hurry, please. I'll tell you. To state, my lord, that whether the legislature, whether the
Enjoys absolute immunity.
as soon as I enter the precincts of the legislature, well, I get that protection under 194. But the reason is not far to seem. There could be number of situations where I may not be called upon to speak. I may get up and say something. I may not be part of the deliberation. The chairman may not be there. The assembly member, the speaker may not be there. Yet the protection is given. Also kindly visualize this situation. 194(2) also uses the
What you submit is whether the house is in session or not in session. You are inside the legislature.
Yes.
So protection springs.
Please. That is the my submission.
All right.
I just wanted to demonstrate this by of two illustrations. Number one, my lords, for instance, in Rajya Sabha, voting takes place. In fact, this PV Narasimha Rao and fallout of Sita Soren were cases of voting. Obviously, the legislature is not in session. Therefore, their lordship said, no, even if the legislature is not in session, that protection is not there. Second is, lords,
Yes.
194(2) also uses the word committee, if lordships have seen.
Yes.
Therefore, as a member of the committee, this under the legislative process, there are a number of subcommittees which are constituted,
Yes.
who deliberate for the purposes of, lords, for instance, recommendation of a bill, etc. In all such cases, that protection extends. On this point, only one more submission I propose to make. Lords.
Yes.
Now, it would be not open for the state, that is the executive, my lord, today before your lordships to say, even interpret to say whether the legislature was in session or not. Now, in order to find out, if I am to deny that assertion, then lordships may have to exercise the powers which are exclusively vested with the chairman of the Legislative Council. The question as to whether it was part of the legislative session or not also, according to me, exclusively belong to the legislature itself. And therefore, I said under Article 226 or 227 of the Constitution of India, it would be not open for them to invoke lordship's jurisdiction to say, please make a distinction here that the legislature was in session, it was not in session. Because now it was not in session, 194(2) is not applicable. The question as to whether the 194(2) is applicable or not should also be decided by the legislature itself, insofar as this aspect of the matter is concerned. Insofar as only the requirement of a procedure is concerned. But as a matter of fact, in this case, the jurisdiction of the chairman has been invoked by the respondent number 2, and a ruling has been given. But I must only add a caveat. The orders, lords, or the decisions passed by the legislature really cannot be relied upon before your lordships, lords, because that forms part of the privilege. By inadvertence, lord, I must bring to lordships notice those proceedings have been filed before your lordships as part of the writ petition. Therefore, in my written submission, I have made it very clear that we do not propose to rely upon that, and we would request lordships not to take into account those proceedings. But the fact of the matter is that the chairman of the Legislative Council has relied upon could be gathered by a letter written by the chairman to the Honorable Home Minister, which I may just refer before your lordship, just to
Now, the preposition muxpidi. Amal will get into the
this what I am now submitting before your lordships is also attended to this for this reason. The question as to whether the house was in order or not. Ultimately, the house was in order or house was not in order. That also has to be decided by the chairman of the Legislative Council. This is the second limb in this submission.
Which page?
Adu memo hakidare. If lordships are see the writ petition, in the writ petition, Lord, I'm not requesting lordships to look into it, but I refer to it. But page 53, if lordships, page 54, if lordships are to see.
In the writ petition itself.
In the writ petition, lordships may kindly see first that.
Yes.
ಇದು ಪೇಜ್ 54 ನ ಮೇಲ್ಗಡೆ ತಾವು ಟಾಪ್ ಲಾರ್ಡ್ಶಿಪ್ ಸೀಸ್ ತಿದ್ದುಪಡಿಯಾದ ಪತ್ರೆ ಅನ್ಎಡಿಟೆಡ್ ನ್ಯಾಯಾಲಯಗಳಲ್ಲಿ ಅಥವಾ ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆಗಳಲ್ಲಿ ಉಪಯೋಗಿಸಿಕೊಡೋದು ಅನ್ಎಡಿಟ್ ನಾಟ್ ಫಾರ್ ಇವರು ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ ಅವರ Siddharth has done it, but I don't say that it could have been done. But this is the reason why I refer to this is this is also a matter which the chairman only has to decide. This has to whether the house was in order or not.
Now, who invoked the jurisdiction of the chairman? The complainant?
Respondent number 2.
Complainant.
The Honorable Minister, she filed a complaint. Then he heard the matter and has given some ruling. Our ruling now, this cannot be relied. But that letter which he writes to the Honorable Home Minister, there he refers to this.
Page.
All you separate memo. One memo hakid. Letter written by the chairman legislative authority to Mr. Home Minister.
Given offhand, it was not with the memo. It was given offhand itself, not with the memo.
Nothing here. Communication, huh?
Letter. Home Minister.
ಯಾವ್ದು ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ದೀರಾ? There is no memo. ನಿಮ್ಮ ಹತ್ರ ಇದ್ರೆ ಕೊಡಿ.
I'll just file it. I'll go to the next.
ಇದ್ರೆ ಕೊಡಿ, ಇಲ್ಲಿ ತೊಂದರೆ ಇಲ್ಲ. You have an extra copy of it, give it.
But lot I'll just read.
ಕೊಡಿ.
There he writes to the Honorable Home Minister, last paragraph, it will give rise to unnecessary confrontation between the executive and the legislature. I request you not to proceed with in his capacity as a head of the legislature, he writes it. But this is only to amplify that he had taken cognizance of this incident and he had given a ruling. This is an important aspect in the matter, according to me. Very, very important aspect.
Next.
So this would be the first submission. Second one would be as to whether if I have to speak something which is derogatory, which is defamatory in nature, which may constitute an offense, in the could it give rise to a situation where a criminal case could be registered? Lordships have referred to Ajit's case. I'll straight away come to that as well.
No, that's the only clarification. If a crime is committed.
The crime is committed. Now the law is well declared and there cannot be any doubt about it. The protection is only in respect of anything said. Yes.
Which has nexus to the business of the house.
Other I'll just put.
Yes.
No, but anything said, I'll put it across in this. Anything said or vote given. These are the two acts which is protected. Obviously, not anything said under they said, therefore they first gave freedom of speech as an absolute right. Then they said anything said, even if you say something, now the law has been settled. I'll point out. Anything said is also absolutely protected. No, the question in Ajit's case, however, a case where there is unruly behavior, giving rise to damage to public property.
There, Ajit's case was not anything said.
It was about public property.
It was an action.
Please.
Not by way of speech, but by way of action of breaking the
mics, etc. Therefore, that is the protection.
There are criminal acts which are performed.
Therefore, that
now here is a statement made.
Yes.
The case here is a statement made. Whether that is protected as
yes,
anything can be said in the legislation.
Yes.